Good afternoon, everyone. My name is Ed Mateen. I'm one of the programming directors here at the University of Chicago Federalist Society. I'd like to welcome you all to today's event, a conversation with Justice Balmer, Judge Ho, and Judge Donnelly. Our panel today features the final round judges for the 2021-2022 Hinton Moot Court competition. I'd like to start by introducing our distinguished panel. First, the Honorable Judge James Ho. Judge Ho was appointed to the U.S. Court of Appeals for the Fifth Circuit by President Donald Trump in 2018. He earned his BA in Public Policy from Stanford University and is an alumnus of the University of Chicago Law School. Before his appointment, he was co-chair of the National Appellate and Constitutional Law Practice Group of Gibson, Dunn, and Crutcher. Judge Ho has served in all three branches of the federal government. On the Senate Judiciary Committee, he served as chief counsel for the subcommittees on the Constitution and Immigration under Senator John Cornyn. The Justice Department, he served as special assistant to the Assistant Attorney General for Civil Rights and as an attorney advisor at the Office of Legal Counsel. He clerked for Justice Clarence Thomas of the U.S. Supreme Court and for Judge Cherry E. Smith of the U.S. Court of Appeals for the Fifth Circuit. He has also served as an adjunct professor of law at the University of Texas School of Law. And now, on to the Honorable Judge Ann Donnelly. Judge Donnelly was appointed to the U.S. District Court for the Eastern District of New York by President Barack Obama in 2015. She received her BA from the University of Michigan in 1981 and graduated from the Ohio State University Moritz School of Law in 1984. Prior to her appointment, Judge Donnelly served as a prosecutor in the New York County District Attorney's Office for 25 years, where she held positions of senior trial counsel and chief of the Family Violence and Child Abuse Bureau. From 2009 to 2015, she served as a judge on the New York Court of Claims. At the same time, Judge Donnelly served at various points on the New York Supreme Court in Bronx County, in Kings County, and New York County, as well as on a special term for election matters. And now I'll pass it on to Ariel Yash.
Thank you. My name is Ariel Ayash, and I am the co-president of the University of Chicago chapter of the American Constitution Society. It is my honor to introduce the Honorable Thomas A. Balmer. Justice Balmer is an associate justice for the Oregon Supreme Court. He is formerly Oregon's 43rd Chief Justice and has served from May 1st, 2012 until June 30th, 2018. He was first appointed to the Supreme Court in 2001 and was elected in 2002 and re-elected again in 2008 and 2014. Justice Balmer received his AB from Oberlin College and is an alumnus of the University of Chicago Law School. Prior to serving as a state justice, he was Deputy Attorney General of Oregon from 1993 to 1997, and he practiced with the Portland law firm Adder-Wynn and its predecessor firm Lindsay, Hart, Neal, and Wiegler from 1982 to 1993 and from 1997 to 2001, and served as managing partner. Earlier in his career, he was an associate with Wald, Harkrader, and Ross in Washington, D.C., a trial attorney with the Antitrust Division at the U.S. Department of Justice, an associate with the Boston firm Choate Hall & Stewart, and in addition has taught as an adjunct professor of law at Lewis and Clark Law School and an adjunct professor of political science at Lewis and Clark College. With that, I would like to pass it off to Professor Masur, who will be moderating this talk today between the judges. Professor Masur needs no introduction and will take it away.
Great. Thank you very much, Ed and Ariel. And thank you so much to Justice Balmer, Judge Ho, and Judge Donnelly for joining us both for this lunch and then for the actual judging of the moot court to take place later this afternoon. And especially thank you very much to Judge Donnelly for stepping in at a very late hour to replace a cancellation that we have. We really appreciate you being here. I'll just note very quickly, we're going to save time for Q&A at the end, especially for the students. You're welcome, of course, to raise your Zoom hands when the moment comes, but also if you'd like to send me a question via chat anytime before then, that's perfectly fine as well, and I can read those off of the chat when the moment comes. So I thought we would start by hearing from our jurists a little bit about sort of their career and path to the bench, and sort of what brought them to their careers on the bench. And in particular, I think it would be interesting to know what, if anything, they found especially challenging about making the transition from practice to judging, and what, if anything, they know now about being a judge that they wish they had known back when they began, that they wish they could have told their earlier selves. So, Justice Balmer, maybe we'll start with you.
Sure. Well, greetings, students. It's great to be with you. I was in Chicago, during 3 Aprils when it snowed. I'm sure it must have snowed. It snowed every day when I was in law school at the University of Chicago. But my path, I'm originally from Oregon. I went to college and law school in the Midwest, practiced on the East Coast. And then at age 30, I got smart and returned to Oregon. And practiced with firms, with a firm there, and then worked at the Oregon Justice Department, and then back to the firm, and then was appointed to the Supreme Court. I think that what I wish I could have done about in terms of being a judge is I would have loved to have been a trial judge for a few years if I'd known that I could then leave that and go to an appellate court. I like the appellate court work. I like it's sort of like, in some ways, it's like writing a paper all the time, writing a 20-page paper on search and seizure, when there's an inventory search of a car that was stopped for a traffic infraction, can you look in the containers? And then, and here's a civil case. Here's an interesting shareholder derivative case. Write a 30-page paper on that. That is being on an appellate court is a little removed from the practice of law, but you're still involved. That's why I like this better than, for example, being a law professor. But in terms of advice for people who want to be judges, I think you should first need to be a really good lawyer, and you need to be as good a lawyer as you can. There are things you can learn from everybody that you see, everybody you work with. You can pick things up, and I don't think I started out wanting to be a judge, but after a while, you see judges doing their work. You think, gosh, that's something that I think I could do reasonably well, and it's something I think I would like doing. And maybe at about the same time in your career, people start to say, oh, maybe this person would be a decent judge. So I think look forward to the opportunities in private practice. If there are judgeships, go for it. And sometimes it works out. A lot of times it doesn't.
Oh, great. Thank you. Judge Ho.
First of all, I am beyond delighted to be back with my alma mater, albeit in this honestly very strange format. I don't think there's anything that can replace in-person dialogue and conversation, and so I regret that we're not doing that. But surely this is better than nothing, and so I am profoundly honored to be part of this, I assume, first ever virtual moot court of Chicago. I think trying to remember the questions. There are many questions, but in terms of the career, I wanted to actually very strongly reinforce and echo what Justice Balmer just said. If I heard correctly, it was sort of starting your career doing some very exciting things in our nation's capital, but then going home. I did sort of the same. Texas actually technically wasn't home. I grew up in California, but ended up going back to Texas, which is my bride's home. And I think that totally agree with Justice Balmer that DC is, I assume I don't need to tell this crowd of young, ambitious, enthusiastic law students, Washington DC is hard to beat, right, as a destination for those who are publicly spirited, excited about the law, excited about the challenges that the legal profession brings, as well as being obviously at the heart of the nation's political system. So in no way would I discourage anybody from going to DC for at least a little bit, if that's something that you want. That being said, DC is honestly has its pros and I'll just say has its cons. and there was no world in which I wanted to spend the rest of my life in DC. And I didn't really want to go back to California. So when I was engaged to my now wife Allison, I was just excited, obviously, to be married to her, but excited, frankly, to have a home state that I was excited to claim as my home state. I've been back in Texas for 15 years, and honestly, taking the experiences and whatever skills I learned in DC and getting to bring it home to a practice in Texas, I felt like I had a very interesting set of opportunities in the law here in Texas, and I got to live here, and so I share that path with Justice Balmer. In terms of transitioning, or what I learned being a still a relatively young judge, I've only been here now about 3.5 years. I'd always understood in theory as a litigator, both in private practice and in government, that judges are generally hardworking, they're devoted to their craft, but they're just very, very busy people. There are a lot of cases on their docket, and when you're in practice, whether in government or private, you've got whatever handful of cases you're handling. But whatever you're doing, however busy you might think, it just pales in comparison in terms of the numerosity of cases on your docket, and so you should be prepared to litigate that way. There's just no world in which your judge, no matter how devoted they are to their job, and then judges, my experience has been judges are by and large very devoted, very hardworking, and doesn't matter how interesting your case is, they're not going to be able to spend anywhere near the amount of time getting ready and learning every nook and cranny of the case law or the record as you do. And so in a way, the job of a litigator, of an advocate, is part teacher as well as part advocate. And of course, being a teacher, you have to be a credible teacher, knowing how to present your case to a panel or to an individual judge in a way that seems and is fair, while at the same time understanding that you're obviously engineering for an outcome that is favorable to your client, and striking that balance. Anyway, I say all that to say that becoming a judge has reinforced that principle in about the most intense way possible. If I was asked, what's my biggest frustration being a judge, it's honestly the inability to spend anywhere near as much time on each case as I used to be in any number of my previous positions. And frankly, even being a law clerk really doesn't give you a full picture. It gives you a good picture, to be clear. But on our court, you get 4 law clerks, and so each clerk only sees at most, at least in a sort of robust way, 1/4 of the docket. And to be clear, it's actually much less than 1/4, because there's a lot of stuff that judges do that we never even give to the clerks. And so a law clerk, you get a picture of what it's like to manage multiple cases, and not just to be learning about them, but actually be casting a vote and putting your name to a position. But even as a law clerk, like I said, you're really just seeing one slice of it. I should know. I actually have meant to look at the statistics, try to figure out how many cases we have to decide in how much period of time. But my bet is it would be shocking to most people. And I can only imagine on intermediate state appellate courts and state trial courts that the numbers are much worse. They really just have to, just get through, and you're almost like a conveyor belt. And that's something for every advocate, no matter what position you hold in the legal system, to always take account of.
Great, thank you. Judge Donnelly.
Well, I guess I'm in the sausage factory aspect of the judicial system as a trial judge. First of all, I'm so happy to be included in today's event. Such an interesting topic. I always learn something from doing moot courts like this. So I'm from the Midwest, and I went to New York, and I never came back. So I've been in New York now for more than 35 years, almost 40 years. And I was a prosecutor for about 25 years as an appellate lawyer starting out, and then as a trial lawyer for a good portion of that. I don't remember what all the questions were, but I'm going to try to do my best. I'd say I think one of the questions was, what's the transition from being an advocate to being a judge? And I would say that the most important quality, which probably serve you well as a lawyer too, is just being able to listen, and obviously be a good lawyer. But I find that I talk a lot less as a judge than I did as a trial lawyer. And that's because as Judge Ho said, I rely on lawyers to give me the foundation for the case, whether it's a factual foundation or uh, a legal foundation. And then we do have just what could be characterized as a crushing caseload, I would say. Having been in state court, sometimes those caseloads are even worse. But we have a full complement of civil and criminal cases. And just one other thing that I've learned is that every case is important to someone. There's no case that is unimportant. And I recall that as a state court judge, if I would handle misdemeanor cases, sometimes people think they're not such important cases, but they are. And so I try to keep that in mind, that for litigants and for lawyers, these cases are all very important. And then the other thing that I try to keep in mind is that having been a courtroom lawyer for such a long time, I have vivid recollections of being yelled at by judges. I think that happened more in the 80s and the 90s than it does now. I'm not positive. But I do remember that it didn't feel very good to be yelled at or embarrassed in court. And so I do try to remember what it's like to be a litigant and how much work you have to do to prepare for your cases. So I hope I'm not mean to anybody, but just trying to remember how it felt to be an advocate.
That's great. Thank you. I want to pick up on the very last thing you said, Judge Donnelly, and ask a question that's maybe of particular relevance to the 4 students who will be arguing later today, which is, what are the things that advocates do in front of you that you think are particularly effective or particularly ineffective? What makes for an especially good or bad advocate in your court? Judge Donnelly, do you want to start us off?
Sure. Well, one thing that I always tell people is that there are 1,000 roads to God. There are 1,000 roads to be, 1,000 ways to be a good lawyer. So it's not always being the most flashy person in the room, but the critical tools that you can bring to your job as an advocate are preparation for your case, which always shows, and being straightforward with the judge or with the jury about what the record is, and making your case persuasively. I've sat on the Second Circuit a few times as a visiting judge, and I'm always most impressed by people that speak plainly, but have a thorough knowledge of the record. One other thing that I don't find particularly helpful, I really don't like it when lawyers, I don't know if fight is the right word, but sometimes people feel very passionate about their position, and sometimes they don't treat each other very well. I find that not helpful. In written submissions, when things are underlined or in all caps, or somebody using the word outrageous. So I sometimes think you have to just remember that the judge doesn't always want to hear that. But I would say the number one thing is being prepared. Just knowing the record of your case, knowing the case law is the most important quality that you can bring to an effective argument or trial.
Thank you. Justice Balmer.
No, I agree with all that. I think that in an appellate court, there are differences between arguing in a trial court and an appellate court, and between arguing in an intermediate appellate court and the U.S. Supreme Court or a state Supreme Court. When you're in the trial court, you're saying, look, this case is like this case just decided by the New York Court of Appeals, or just decided by the Second Circuit. And so it's within this line of cases, not that line. When you're before, and similarly in an intermediate court of appeals, This is what, like this line of Supreme Court cases, and here's why. When you're in a court of last resort, we're trying to figure out what should the rule be, and you're not going to get away by saying, "Oh, this is like your other cases, but not at all like these cases that your court decided." If it was like that, we wouldn't have taken the case, wouldn't have allowed review. We took it because it's going to give us an opportunity to articulate an important rule for the lower appellate court and the trial courts. So think about, particularly if you're in an appellate court or a court of last resort in particular, what's the limiting principle? What's the rule of law you really want to come out of this case? It's not just, as you are in trial court, just trying to get the ruling in your favor. Think about that. Certainly no ad hominem attacks, no statements about what an idiot the trial court was or how awful the opposing counsel is. No jury issues. Don't tell me how bad the injury was. That we're here in an appellate court because there's a legal question, and I want you to help me, for you and your client, figure out what the correct answer to this legal question is. It's a discussion.
Okay, terrific. Thank you very much. Judge Ho.
So I want to pick up on a theme that I think Judge Donnelly opened with, which is that seeing lawyers bicker, and what Justice Balmer said about insults towards anybody is one of the worst things you see as a judge. Hopefully you don't see many insults in the courtroom, but you do see quite a bit of fighting and bickering. And I think it sort of misunderstands how the litigation process is supposed to work, even though it's actually quite common for lawyers. And it certainly misunderstands the appellate process. And I think of the appellate process in particular, but I would think lawyering generally, as one that you should view primarily as an intellectual exercise, at least in front of the judge. I'm not a jury. I've never done a jury trial or anything like that, so I'll let others speak to how to handle juries. But certainly from a judge's perspective, it's an intellectual process. And so I think advocates are better off when they view it as an intellectual process as well. And towards that end, being intellectually honest. Everybody understands that you're there wanting a certain result. Nobody will be confused by that. Given that, making sure that you are always candid, making sure that you maintain your credibility at all times. We understand that you're pushing for a particular position, but if you ever overstate something, whether it's saying that a case says X when it doesn't quite say X, saying that the record proves Y when in fact it doesn't, those are not good moments. And those are moments that I certainly remember when a lawyer has told me something, and either in that moment or later on, I find out that turns out to be not true. It's not just that you've lost credibility on that moment; it's that you've really lost credibility across the board. One of my dear friends is actually one of the advocates in that case that we're going to be mooting today. Mark Perry at Gibson Dunn used to tell us, as rising appellate associates, if we can't trust you to get the commas right, we can't trust you to get the law right. And I always took that very much to heart, that both as an associate, just doing a good job site checking and whatnot, but also as an advocate, talking to judges, never, ever, ever destroy your credibility, because you can build a lifetime of good work and reputation and destroy it in a moment by overstating. And then the last thing I would say, absolutely, it's all about preparation. One specific aspect I'll note is, particularly when you're at the appellate phase, understanding that there's multiple ways to look at a case. So I always would tell, when I had to moot a case in practice, I would always have a moment, halfway or so through the process, I would ask everybody, okay, if we could change sides right now, obviously you're not allowed to do that, but if you could, hypothetically, would you do it? Would you want to switch sides, and why? That inevitably created interesting dialogue and allowed us to probe our case in yet another way. So certainly trying to understand exactly why the other side has good points, and really trying to appreciate why their position is not as crazy as you might want people to think. and really get in under the hood on that. But also not just switching sides, but also understanding that your judges, who are not obviously on any side, they're just trying to decide what the law is, that judges have different views. So understanding originalism, understanding textualism, understanding the role of precedent, understanding that people do care. Even the most hardcore originalists at least wonder what the practical consequences. And so being able to understand a case and all the various aspects of it through every possible lens. You know, if you're relying heavily on precedent, that's great, but you better have a reason why the precedent is correct or fair or good for the society, or at least good textualism or good originalism. Having all those things nailed down in every possible way. That way, hopefully, if you're prepared enough, there's no question that you will not expect.
Great, thank you very much. I guess I'd like to ask now about sort of parts of your docket, the types of cases that arise in front of you. And I'm curious whether there are particular parts of the docket, maybe particular subject matter areas of cases or types of cases that you find particularly difficult or challenging in some regard, or parts of the docket, maybe it's the same, that you find especially interesting or especially rewarding in some regard. Certain types of cases that you have particularly strong feelings towards, given the different types of dockets that I assume your courts experience. So Judge Ho, maybe you could start us off with this one, please.
Sure, that's a great question. One of the both benefits and detriments of being a generalist judge, just like I was actually a generalist appellate lawyer previously, is that you get to try something new every day and learn new areas. With that said, there are some areas of the law that are relatively straightforward, and others much less so. And in particular, what I'm going to focus on is those areas of the law that really actually don't really feel like law. To give you one recent example for me is I forget the name of the statute, but it's the IDEA, Individuals with Disabilities Education Rights. Those types of disputes typically involve having to get very detailed into scientific disputes and disputes about educational pedagogy, specifically in the context of the mentally disabled. We're judges, and Congress has called upon judges to decide those disputes, and of course we try to rise to the challenge. But I got to tell you, that's not an area of experience for me, and so I get really nervous trying to figure out which expert to believe, and I worry that I'm really kind of outside my depth. You know, you give me a statute, I can, I'm 20 years on the law, I can, figure it out, or at least I can figure out why it's hard. And so, those areas I get. But anytime when you have a dispute that really rests on battles of the experts, I got to tell you that I start to worry that I'm outside my depth. Perhaps that's the benefit of being an appellate judge. I think Justice Balmer may have alluded to this. Is we basically get to defer to the district court, and so as long as it's a close enough question, then we just kind of bless whatever happened below. But that, of course, leaves it to district courts to have to make those calls in the first instance. And I don't even know how juries handle it, because they're literally obviously having to make the call themselves. So anyway, that to me, that's where I get the most nervous.
Great, thank you. Judge Donnelly.
Well, we had a little chat about this before this session, and for me, and I think for most of my colleagues on the district court, the hardest thing that I have to do is sentence someone. That is, it is just very emotional experience for the person being sentenced, and for the person's family, and for the community in which we live, and determining what is an appropriate sentence in a criminal case, I find to be just quite difficult. And it makes you think about to what extent incarcerating someone is a solution to the problem, and to what extent you need to protect the community. You think about, as I said before, just the kind of radiating effect that incarceration can have on a family. When a district judge sentences somebody, we very often have letters from family members and friends, and they're very important to me to try to get a picture of the person who's appearing before me. In the district court, the most cases are resolved by plea, and so we don't always have the opportunity to see the person in our courtrooms all that often before the person enters a plea. So the input from a person's family and people that know that person become very important. So that's the kind of difficult cases. The other part that's difficult but also fascinating is that I think other judges have referenced this before, is that we are generalists. And so every day we are seeing something different. And something new, something that I've never encountered before. I was a prosecutor for 25 years. I did not really encounter patent law very often at the Manhattan District Attorney's Office. So learning about new areas of law is something that's extremely challenging and makes for long hours. But it's why we have judges on one judge on our court who's going to be 100 this year, Judge Weinstein, and I think this is what keeps us going. So I hope I answered that question. I think I did.
Yes, that was great. Thank you very much, Justice Balmer.
Yeah, I'll agree with the generalist aspect of the job is great. I had a pretty broad civil practice as a lawyer, but here we do criminal law and tax law and all sorts of civil cases, from real estate to, I had an adverse possession case. The fascinating issue of got into the restatement of property and the development of various doctrines of adverse possession of common law. A ton of fun. So it's a little, sometimes I sit around with my colleagues and we say, God, they're actually paying us to do this. They're paying us to figure out this issue that involves a dispute between the governor and the legislature. How lucky can we be? And we feel very lucky. I didn't practice criminal law. Criminal law, I find, and I'm glad I don't have to do the direct sentencing. Again, this is the trial courts do this, and we're reviewing it. Did they comply with the statutes, and does it comply with any constitutional limitations? But I think that most difficult cases, sort of factually, and they're very complicated legally, are the dependency cases. When can the state intervene in family relations because the parents are either unable or unwilling to take care of their kids? And when should parental rights be terminated? There are deep, serious constitutional issues there. The facts of these are heartbreaking, but they still have to be decided in general. As Judge Ho was saying, this is the kind of case where we're going to often defer to the trial court, who has seen the people in this family. They may have seen several different children. They may have seen struggles with addiction or incarceration by the parents, and we're often going to defer to them. But there are legal standards that we have to ensure are met, statutes and constitutional provisions that have to be complied with, as well as just the heartbreak that goes on in some of these cases. I guess the other type of case that I don't like that much that we have to do, and that my federal colleagues don't, are lawyer discipline cases. We enforce the rules of the Oregon State Bar. Those are, we have de novo review, so we're supposed to really look at the record carefully. Those are sort of tough cases, but in general, most courts, certainly our court, we spread the cases around. Everybody does some of everything. We don't have a tax specialist or a real estate specialist who gets all those cases. There's the kinds of issues, they're interesting issues to me, causation in torts, damages issues in tort cases, some corporate litigation issues that, because I dealt with those sorts of things in private practice, I think are interesting. But we do the gamut, and it's always a challenge when you open. Here's a giant new set of briefs to read. I don't know anything. It's like reading for this. It's like the appointments clause. We don't have many appointments clause cases in the Oregon Supreme Court, and this was a ton of fun. But you're starting from scratch every time, so you have to be willing to sort of make another cup of coffee and sit down and dive into it.
Great. Thank you so much, Justice Balmer. So given the number of students in the audience, I think I would be remiss if I didn't ask about the role of clerks in your chambers. And so I guess I wanted to ask, first of all, sort of what role do clerks play? How do you, employ your clerks? How do you interact with them, and kind of what do you want them to do with your cases? And then also, what do you look for in a law clerk? What makes a good law clerk in your chambers? So Justice Balmer, maybe you could start us off, please.
Sure. Well, we only get one clerk. That's it. We have some staff attorneys, but I hire clerks. I've had a Chicago clerk. Like the U.S. Supreme Court, we have a discretionary docket. So we have petitions for review, which are like cert petitions. And one of the clerk's important roles is going through my share of the petitions and making reviewing those cases, reviewing petitions that come in, making a recommendation to me. I then either agree or disagree or write a comment on it and forward it to the rest of the court, and then writing the opinions that have been assigned to me by the Chief Justice. If I get assigned a couple cases from a series of oral arguments, I'll say to the clerk here's what the court said in our post-argument conference about how we think this ought to come out. Chief Justice Walters has a concern about this issue, but I think there's sort of a consensus around this. Why don't you start on a first draft, and we want to hear some points that people made at our post-argument conference, try and include these. We have a somewhat more complex case in an area that you don't know anything about. I'll take a first cut at this one. So that's the work of a clerk on a court of last resort with a discretionary docket. These petitions that we get, the cert petitions, essentially doing some of those and then doing some drafting. In terms of, I'm looking for somebody who is a good writer. Good writing is just incredibly important in all courts, but appellate courts in particular. I'm looking for somebody who can talk and is willing to talk with me about legal issues. So in an interview, I don't really care. I mean, I care as a person, what you did last summer and, where your next trip is and what's happening in your personal life. But I want to talk to you about a legal question and have a good discussion and understand whether you are willing to engage in sort of an intellectual debate about, how should we structure, this redo we're engaging in on the way, corporate reorganization ought to be redone under Oregon law. So can you talk about legal things? And one thing, this is on your resume or your submission to a judge for a clerk application. I at least don't want to see the really interesting paper you wrote about the law of the sea or how we ought to be dealing with climate change through international institutions. We don't do those sorts of things in our court. I want to see, the motion for summary judgment that you wrote when you're working for a law firm in some sort of, I don't know, tort case or contract case of some kind, or if you were working for the DA or the public defender. Let's see the motion to suppress that you wrote, something that relates to the kind of law that we do. I'll end there.
Great, thank you. Judge Ho.
So I would sort of go back to what I said earlier about there are just a lot of cases on our docket, a lot of reading to do. not just the briefs, but getting into the underlying case law, obviously reading any relevant statutes, going through records. It is a ton of work. And honestly, there is not enough time in the day to do it all, just to be very blunt. And so because of the nature of the workload, clerks are critical. This job is, I would submit it's impossible to do. And it's certainly impossible to do in any way that I would feel minimally confident about without law clerks. I need people to help make sure that we are deciding every case correctly. I think Judge Donnelly put it exactly right. Every case is critically important to the parties involved. From the judge's standpoint, we see lots and lots of cases, and we try to teach. We really genuinely regard each one as we understand that they're important to the parties. But there's so much to do that I frankly do worry about making sure that we have not missed something. And so I trust my law clerks implicitly and explicitly to make sure that I have not messed something up, that I have not missed something, that we have adequately addressed every argument, that we have not missed some critical part of the record. And so clerks are not important, they're critical to the process. What I look for are, in addition to all the criteria that everybody looks for, good grades, et cetera, I think legal writing absolutely is critical, as was mentioned. To be honest, I think legal writing is something that not many people know how to do, at least not know how to do well, particularly at a law school. It's just something that really takes a lifetime of practice. But it's honestly, at the end of the day, it's speaking clearly, speaking in a way, not like a lawyer. So to make it easy, obviously we're all lawyers, and the audience of judicial opinions is by and large lawyers. But even in that legal community, to make things as easy and accessible to understand, so that the world knows what the law is, and so citizens and entities can know how to comport themselves to the law, or at least know what the consequences will be when they don't. It's critically important to provide that easy accessibility. And so writing crisply and clearly and succinctly and to the point is essential, but frankly, much harder than people realize. And in particular, I want to hire a law clerk who knows how to push back, who is not going to just say, yes, judge, whatever you say, judge, you're so smart, judge. That's the last person I want, because, I could find somebody to compliment me. What I want to do is to find somebody who's going to challenge me to make sure that I don't mess up on these very complex cases that are too detailed and too numerous for me to be perfect on my own.
Great, thank you. Judge Donnelly.
I should start by saying that I would never have hired myself as a clerk, but so I feel very fortunate in the clerks that I have had. The most important thing to me as a district judge is to move my cases so litigants get decisions as efficiently and quickly as possible with the correct result. And with the caseload that we have, that is a big challenge. So my clerks help me to do that, make sure that there's not something that's been sitting on the calendar too long, or something that maybe in another case could wait, but in terms of the particular case has to be decided or should be decided quickly. I also rely on my clerks to give me their practical take on a case. I want to know what they think about it. And like Judge Ho, I want them to make sure I'm not doing the wrong thing. I want to make sure I haven't missed something, that I'm reading the cases wrong, that the Second Circuit is going to reverse me. Or that I'm just making a bad decision for the parties. So I could not function without them. In terms of what I look for, I always hire law clerks that have had some practical experience, because I think that as wonderful as the educations are that we get in law schools, once you're out in the world and you're really, putting your skills to work, I think you learn so many things that you never would have expected. when you were in law school. So I look for somebody with a little bit of experience, and I look for people that that are, in addition to being brilliant, which all of you are, and all of my law clerks are, that they get along with people and that they are good listeners too. And as I say, if you have a heavy docket, you've got to be able to move it, and you've got to be able to get things done pretty fast. And so so somebody that can handle all that is critical to getting the work done well.
Wonderful. Thank you very much. Okay, so we have about 20 minutes left. So I think it's a good moment to open it up for questions and answers from the audience. So if you've got a question, you're welcome to raise your Zoom hand, or you can send it to me via the chat also.
Thanks, Professor, and thank you to all three of the judges for being here. I have a question. All three of you had touched in some way on the general nature of judging, and that some of you came from backgrounds that were generalists. Some of you, Judge Donnelly, came back from a background with a particular focus. And I've talked with Professor Masur in class about how it's kind of strange that we have general judges, that we don't have a system that has, you know, if you have a really naughty bankruptcy question, we're going to send you to this judge on the Fifth Circuit that has a lot of bankruptcy experience. And you kind of see this in a quiet way. You know, if there's a tricky bankruptcy problem in the Third Circuit, there's a good chance Judge Ambrose is going to write the opinion. Or, you know, in the Seventh Circuit, it's going to be Judge Wood or Judge Easterbrook. What are your thoughts on this? Do you think courts do this in some way that, you know, it seems that cases that play to a judge's or justice's strengths get assigned to that judge or justice? Do you think we should move to that system in like an explicit way, that we think judges, you know, should own their skills and not sort of stray beyond sort of their experiences? Just general thoughts.
Great, thank you. I'll let the distinguished three panelists answer that in whatever order they would choose. So please feel free to jump in.
I'll try to take a quick stab at it. I think it's a wonderful question, and I honestly seriously doubt that I'll be giving you an answer that is worthy of it. I almost want to think about it for a few days to get back to you. But one thought to be sure is, I think that's one of the reasons why we have multi-member appellate panels. You know, at the end of the day, we benefit as a legal system from having different voices involved, different judges to check each other, if you will, to make sure that we're getting these questions right. We don't have, by and large, an expertise-driven judicial system. Obviously, you've got the Federal Circuit. It's funny you mentioned bankruptcy. We obviously do have bankruptcy judges. But as you note, though, on appeal, the bankruptcy judges, perhaps ironically, are reviewed exclusively by non-bankruptcy people, but by generalists. And so I think that's for one reason why we have multi-member panels, and one reason why collegiality is so important, because we do, you know, I don't know about every court, but certainly most courts, you just by sheer fact of numbers, you will have different people with different backgrounds, both personal and professional. And so you can kind of rely on each other. I remember some of my colleagues have made clear they like having some number of colleagues who have had district judge experience. You benefit from people without that, to be sure, but you want to make sure you have at least some people with district judge experience, because you get such an amazing insight into how rules and decisions that we make impact day-to-day litigation. That's something that if you don't have that experience, you wouldn't necessarily know. And so having a collegial bench where we genuinely respect each other and listen to each other, doesn't mean you have to agree with everybody, but you get that everybody's there in good faith, just trying to help the process. That is huge, because then you can trust that the person who does have bankruptcy experience, and we actually do have a few on our court who came from bankruptcy practices. I believe Judge Jones, Edith Jones, served on the National Bankruptcy Commission. And so it'd be natural for us to listen to her, to Judge King, people on our court with that experience, and hopefully vice versa. Hopefully everybody brings something to the table.
Judges, one of the occupational hazards is we talk too much, and so everybody can always jump in every time. But I'll jump in just for a second. I think it's a great question. That's more of a question. I sort of put that in the bucket of well, what's your legal philosophy? I don't have a legal philosophy. Let's let the law professors in Oregon, that 2 or 3 of them that actually read our cases and think about what we what our trend is. Let them talk about that. That's a great question for a law professor, I think. As a judge, I buy into what we've got, which is a system where we do have expertise in some areas, bankruptcy, tax court. We have a state tax court judge. There's one tax court judge, and we review his cases or on appeal. They come straight to us rather than the Court of Appeals. I'm glad he's there. I'm glad he gets to sort all this stuff out like a bankruptcy judge. Many states, including Oregon, have, although we have a single trial bench of essentially like the federal district court, they're called circuit judges, but there are some that do just criminal, and it depends on whether it's a court that has 40 judges or a court that has one judge. If it's one judge, that judge has to do, in Harney County, that judge does the criminal cases, the civil cases, and the juvenile dependency cases. In larger courts, there tends to be more specialization because the law is very complex, and we do depend upon those trial court findings, and in many cases on the expertise that the lawyers who do these dependency cases, abuse and neglect cases, termination of parental rights cases on a regular basis, day in, day out. Now, it's great that it's the same reason we have generalist judges reviewing bankruptcy decisions. They can get too used to dysfunctional families that they're not giving everybody the procedural protections that they're entitled to. And that's one of the reasons that we have in this country, we've always had, U.S. Supreme Court and all these state Supreme Courts that essentially are generalists. Now, in some states like Texas, they've got their own criminal Supreme Court, and then what's called the Texas Supreme Court is really a civil court primarily. But I think that the law has to work for society as a whole, and I think generalist judges, particularly at the appellate level, and there's a lot of reasons to have them at the trial court level as well. But I buy into that. I think it's a super interesting question that you could have a whole seminar on it, Professor Masur.
I don't have a whole lot to add to that. I mean, obviously the district court, we are generalists, but there is obviously a bankruptcy court. And even within the district court, judges can, at least in our district, can sign up for the patent wheel and to get patent cases. People can be on the multi-district litigation panel. And so you can make those selections. I don't know at the trial level or the district court level how practical it would be to divide cases up too finely. Obviously, as a state court judge, I did almost exclusively criminal cases. But I think on the federal level, it's a little bit different.
Great, thank you. I do think this is an especially interesting question in light of the moot court case for today, which is, of course, a patent case. And patent law is one of the areas that is most divided, most sort of sent to specialized judges, such that only one of the three of you would ever have a patent case in the normal course of your judging life. So maybe moot court is a welcome change, or it may be an unwelcome change. There's a question in the chat from Katya El Tayeb, and she asks, in light of your very hectic workloads, which all three of you have discussed, do you have any writing tips for lawyers or soon-to-be lawyers about how to make your lives easier and how to streamline and tee up effectively the matters that come before you?
I guess I can start with that one. Yes, don't make it too long. I have lots of requests. In every district judge has individual rules, and we have page limits. And a lot of times people will say they must exceed the page limit. And I never say no, really. But a lot of times I will say you don't have to use all this extra time. I do think that one of the keys to being an effective advocate is to be able to say something succinctly. And it's been my experience that um, it's much harder to do that in a shorter period of time. I don't think everybody, and I'll only speak for myself, maybe my other colleagues disagree, but it's kind of like a speech at a dinner. Nobody ever leaves wishing your speech had been longer. And I think that that is pretty much the same thing with the submission. I never wish, gosh, I wish I had more. So, and maybe that is not the feeling of my fellow panelists, but but I feel that way.
I strongly agree with the brevity point. I've never read a brief and thought it should have been longer. And probably half the briefs I read are not terribly good, and in any event could have been shorter. In addition, I guess what I would say is, and this maybe sounds surprising to say out loud, but I wonder if some brief writers don't actually stop and think about their case before they start writing. They just sort of just start writing and then stop when they're done talking. There's a logic to these cases, right? There is a framework that the law hopefully provides, and there's a hierarchy in our legal system. Sitting and really nobody should sit down and write a brief until they've thought about the case very, very deeply and really thought how best to organize it. And then once they do start writing, it should go through multiple drafts. Any important piece of legal writing should have countless revisions and drafts. One possible mental framework that I used to share with people is, imagine that you have the most important thing that you've ever wanted to convince the President of the United States to do. Okay, and it's the President of the United States, very, very busy person, but enormous power. They could do a lot to further your cause, whatever it is. I don't care what the cause is. And you have 5 minutes to talk to them, or you have 5 minutes where they will read your memo. I'm pretty sure if you were literally in that situation, you would spend untold amounts of time thinking about every sentence. You'd obsess about what word you began with, how best to grab their attention and to never let it go. You'd be trying to find a way to convince the president this is so interesting to read, at least, that they should spend 6 minutes. You get my point. I won't belabor it. That should be the approach, if you can, to everything you ever write. Because although you won't typically litigate in front of the President of the United States, you will litigate in front of people who are very busy, but who have at least some measure of judicial power to do what your client needs them to do. And so, if nothing else, think of it almost as a courtesy to the busy judge. Make it easy for us to understand what the dispute is about, what's at stake, and sort of, what individual decisions we need to make in order to decide ultimately whether we're affirming or reversing or granting judgment for the plaintiff or the defendant. Make it as simple as possible.
I don't have any tricks of the trade. As a trial lawyer, I think I wrote better and more succinctly because I knew I was writing for Judge Donnelly or for her clerk. And in state court, you knew you're writing for the judge, and the judge is going to read this, and they might read it the second before they come out to hear a brief argument on it. And you have to say, here's why I should win. Here's this recent case. Here's the quote from it that shows why I should win. Short, punchy sentences, not so punchy as to be clever, but direct and to the point for a district judge. I do not have a solution for how to write succinctly as an appellate judge. I don't know if you guys were limited to 10,000 words. Is that right? I actually sent a text to my clerk last night saying, check on the federal brief length requirements, because I think ours are too long. Our briefs are way too long. Now death penalty cases, we get 100, 200, 300 page briefs. but in general, especially if you're at a court of last resort, or if you're a U.S. Supreme Court or your state Supreme Court, they don't want to hear the 10 reasons that the 10 mistakes the trial court made. They want to have the one or two or three issues that are absolutely critical. At an intermediate appellate court, it's much more defensible to say you need to raise every credible thing, and in a criminal case, of course, the credible things that you think the trial court got wrong. But when you're seeking review in a state Supreme Court, or certainly at the U.S. Supreme Court, and as my colleagues know, that some of the most compressed, thoughtful writing is in the question presented in your cert petition. And if you don't spend, 2 weeks trying to figure that out, and how you're going to grab the court's attention there, you might as well, not be charging your client for that time, because there are people who are experts at this, people like Gibson Dunn or other, the solicitor's office. But I do think also that you have to print them out. I think that writing on the computer, where you can forget what you said 3 pages before and now you say it again, the amount of redundancy that creeps into briefs or into appellate opinions is phenomenal. And you've got to be able to print it out so you can see, oh, what I said on page 6, I said essentially the same thing again on page 10. And you got to be ruthless in your editing, but it's very hard.
Great. Okay, so I think we have enough time for maybe one more brief question. So Alex, please go ahead.
Yes, thank you all so much for chatting with us. I've really appreciated your forthrightness. I'm wondering if you might be willing to share a moment from your career, maybe as a clerk or lawyer, advocate, time in government, that you feel informs your approach to being a judge, and maybe taught you a lesson about how to be a thoughtful and effective lawyer.
When I was in the Bronx Supreme Court, we heard all kinds of cases, felonies, misdemeanors, and at one point they had combined the misdemeanor and felony docket, which was a terrible idea, but that's not the point of the story. There was a man who was accused of turnstile jumping. The Bronx Supreme Court is the busiest place imaginable. Courtrooms are crowded. There's all kinds of stuff going on. And this man's lawyer had not come. And so, one thing I could have done was just put the case over so the man would come back another day. But I just decided I wasn't going to do that. So I appointed a new lawyer from the audience. And the lawyer was trying to get him to just take a plea to it's a violation. It's not a criminal conviction, but you have to pay a fine. It's not cheap. And the man was just sitting there, and then he said, "Well, Judge, I've come back here so often, and I have this paper, and the paper showed that he was using a Metro card, that he'd paid the subway fare. He didn't do it, and nobody had bothered." I'm not saying I was so fabulous, but nobody had checked this, and the guy had come back to court, these many times, and somebody was going to have him just plead to something so he would pay this fee. And I just remember thinking to myself, be careful, be careful when you are making these decisions, even in a case that doesn't seem so important. And it really was something that I've never stopped thinking about that case, about just that. And then, of course, it took moving mountains to get the district attorney's office to dismiss it. But that was my powers of persuasion. But anyway, it made me think, made me realize, I think it's something I always knew, but you just have to be careful. I mean, and that's a little tiny thing, but it sort of relates to my view that, and everybody's view, is that every case means something to somebody. And so I don't know what lesson I learned from that, except that I I just think about it. It's something that I always think about as a judge. So that's mine.
I want to follow up on something Judge Donnelly said earlier about judges who are difficult. When you enter whatever legal community you'll enter, I'm just going to assume that you're going to start to learn about. There's that one judge in that courthouse that nobody wants to be before. It's going to be an unpleasant experience. They're going to pick on somebody, perhaps randomly, perhaps due to some philosophical bias or whatever. Doesn't really matter for my purposes. And I've in practice seen my share of it. Thankfully, I've not been the target of it very much, but certainly seen others targeted as well. And I just vowed that is pretty much the worst thing you can do as a judge. The purpose of judging, the purpose of our legal system, is not just to resolve disputes, but to make sure that the litigants feel like they were heard and they had their chance and they won or lost, but they got a fair shot. And when you have an experience where the judge is being very, very difficult during questioning or what have you, it just leaves a bad taste in people's mouths. I actually think that there may be some judges who sort of see it as sports. It's sort of fun to beat up on a lawyer. And I find that, thankfully that is not by any means prevalent. I want to make that clear, but it's not zero. It does happen. And I think it's completely antithetical to what judging should be and what the courtroom demeanor should be. What we're doing is trying to search for truth. At least that's what I think of it is. We're trying to figure out what the right decision is, what the law is, and what the facts are, and how do we apply it. And so it should, far from being a hostile experience, it should be a conversational engagement. There's limited time, so there are times when judges can be short, but hopefully it's not out of any sort of temper or desire to be difficult. It's just, you have an answer, but you're kind of getting off track, and we're trying to get to a point. But hopefully it's as accessible as can be, understanding that the stakes are high and emotions obviously do run high as well.
I'll tag on to that too, and again to the theme that every case is important, and just hit for a second on the importance of procedural due process and the role that lawyers play. I took a pro bono case through the Volunteer Lawyers Project or something in Portland. Somebody was being sued by the debt collector for a hospital because the hospital had taken care of her daughter who tried to commit suicide. And she'd been paying like $10 a month for years. She finally lost her job and couldn't pay anymore. And they sent it to a debt collector. It turned out the daughter was over 18 when she had tried to commit suicide. The mom had no legal responsibility for the debt at all. And a law student could have figured that out. I, as a fifth-year lawyer, figured it out. And and eventually, and they said, "Oh yeah, she agreed to pay." Said the debt collector and the hospital. I said, "Okay, send me the documents, and then we'll take a look at it." No documents. Go, and then I said, I'm going to ask for sanctions for this frivolous lawsuit if you don't dismiss it right away. And they finally dismissed it. But I have sat as a trial judge on occasion, and I've seen how much better off a litigant is with a law student or a first-year lawyer, or even any one of you, compared to if they did not have a lawyer. The lawyers really, Richard Epstein told me that the lawyers are the grease that makes the wheels of not just the economy, but of society turn as well as it does. Now, we fail all the time. The system fails all the time, but lawyers can make it better. And I think of that person I represented in that, tiny little, it was like a $10,000 case, a lot of money to her. And we do and you do make the system work in some way. It's got its faults, but we can help improve it.
Great. Thank you very much. There are obviously more questions, but we are unfortunately out of time. So would everyone please join me in thanking our three tremendous panelists.